Morning, sir. Are you Brian Snipes? And Mr. Snipes, in clause number 24, DCCR 2174, you're charged with the state jail felony offense of theft of mail with identifying information from February 2nd of 2024. Your indictment alleges that you were previously convicted of burglary of a habitation, a second-degree felony, February 18th of 2014. Okay, so it looks like two.
It looks like they're not sequential.
They're not.
Those priors. However, Judge, I do have in my possession a federal judgment that I intend on filing a notice of enhancement for the purposes of the record. It's a.
What's the date of the final conviction?
It's been a while since I looked at it.
February 18th of 2014 is the possession and the burglary, both second degrees.
February 18, 2024.
2014.
2014. Oh, 2014. Okay.
Yeah, Judge, I have a.
What's the date of that one? I'm sorry.
It's a. This one's from 2016. It's a federal possession and distribution of meth, along with the gun charge the defendant received a 93-month sentence on. My plan is to file a notice of enhancement, including that federal judgment, to get him to the 20 punishment.
Yeah, you'd have to see. I'm not sure if the 2014 conviction was final by the 2016 date, or whether there was an appeal or mandate, something like that. So I would admonish him on a second. But he in any case, he wants a trial.
So I do want to make sure you understand, Mr. Snipes, that if those, the felony conviction that I've read, those two, and the one that Mr. Coleman has that he's going to file a notice to enhance, if those are actually sequential, so one was final before the other one was convicted, that means that your punishment would be enhanced to that of a second-degree felony, which is a minimum of 2 years up to 20 years in prison. Do you understand?
Yes, ma'am.
And I have here on the tablet a plea bargain rejection that you've signed with Mr. Kimler that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 10-year term in prison. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to plead guilty.
Yes,
Do you understand all of that?
yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, we'll get it set on the trial docket. Mr. Kimler will begin preparation for trial. Stay in touch with him and he'll let you know when you need to be back ready for trial.
Just for clarity purposes, I think in order that 10-year offer to be valid, those would have to be sequenced. I don't
Yes.
think one of them would get him to a third, since they're not a 3G offense. So
It's either a state jail or a
state
second.
jail or second.
Yes.
In the event that those aren't sequenced, then I don't want him to forfeit the opportunity.
No, if there's some issue with the sequence, no, if there's some issue with it, that's why, yeah, I didn't,
I would agree to stay with.
Because they may
Of
come back
course.
with an offer in the state jail.
sure,
So,
Yeah.
all
that
right.
yes.
You can go.
Derek Wells. Good morning, sir. You're Raquel Glover. And this is 24 DCCR 0232. Mr. Glover's case is set for trial to begin with jury selection next Monday. And what is the announcement?
Your Honor, State Attorney made an offer of probation in this case. Mr. Glover's advised that he's refusing that, desires to proceed the trial. I'm announcing ready.
All right, all right, so Mr. Glover, your case is very old and likely to be at the top of the list next week. I do want to make sure you understand that after today, I will not accept any plea agreements. So if you change your mind between now and Monday, you can plea open to the court, but you're not going to come in Monday last minute and think that you're going to get some other deal when we have a jury waiting. So we'll have your case will get numbered tomorrow after the docket. So stay in touch with Mr. Kimler. He'll know that trial order, but I anticipate seeing you Monday at 1. Okay. All right. I'll see you then. Good morning. You're Wayne Cummings.
Yes.
And this is 18-29640. There's a motion to revoke probation that's been filed. And what is the announcement?
It's the MPRP is based on a new case out of Orange County. Mr. Smith checked last week. It had not yet been filed. So I kind of, other than ask if we could have a recess for that to get done.
Well, that's what we've been resetting for. I mean, the motion was filed of 2025 and we've just been coming back and
Right.
waiting.
The offense date is October of 25.
Right. And, but is there any note on where they are on getting that taken care
I
of?
don't see anything about where it is, judges, it has not even.
Okay.
That was, he called them last week.
All right, so if you'll just make a notation for Mr. Smith to get with them again and find out, I guess, what the holdup is, if they anticipate it being filed and not just whether it has or hasn't, so that we can move forward one way or the other next court date. All right, stay in touch with Mr. Kimler and your bondsman, and they'll let you know when you need to be back, sir. You're free to go.
Good report for probation.
Raphael Glover, Mr. Kimler, and Mr. Nichols.
That's mine.
Good morning. Are you Devon Murray? Speak up.
Yes, ma'am.
And this is cause number 26 DCCR 0346. Mr. Murray was previously in court, entered a plea of guilty to the second-degree felony offensive robbery. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Are there any additions or corrections?
Not from the defense, Your Honor.
There's the only thing I have, just more for the court's knowledge than anything else, with respect to the statement of the interested party. The co-defendant in this case is Jose Lugo, who is also before this court. I've just asked you to take that into consideration when you see that case coming.
I mean, you guys both read the recommendation of ISF. correct?
Yes, Your Honor, and I've spoken with Mr. Murray in regards to that. I did tell him that I would ask the court to hold it in abeyance if possible to see how if he can get started with probation. But he does know that that is a decision for you and whether that will be held in abeyance or not.
So it's not going to be held in abeyance. So you're young. This situation I mean, the whole point was buying and selling guns, and that's just a big problem about what's going on right now. And so ISF is not necessarily meant to be a punishment. It's meant to give you some tools. You're very young, so that when you do that program and you get out, you can be successful on probation. Because what I don't want to do is put you on probation, not give you those tools, you mess up, and then come back in and go, well, don't revoke my probation, send me to ISF. So I'm going to send you now. You're going to get those tools. Then if you mess up, it's going to be even worse. You understand? All right. So I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 4 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. That will include entering and successfully completing the cognitive track of the ISF program. You are not to have any contact whatsoever with the co-defendant, Jesus Lugo, and also with the victim, Kiera Davis. Do you understand? And that obviously means contact in person, but it means any type of communication through electronic media or Snapchat or any of that kind of stuff. You understand? You'll be on the high medium caseload when you get out of ISF. That's also to help you get started on probation and to be successful. This is an excellent opportunity for you because you don't have a felony conviction on your record. And if you successfully complete the probation, then you'll never have a felony conviction. You'll be able to go on about your life like the rest of us without being a convicted felon. The other side of that, though, is if you violate any condition of probation at all, you can be brought back into court. You could be found guilty and you could go to prison for anywhere in the range of punishment, which is between 2 years and up to 20 years in prison. Do you understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed. And so you've waived your right to appeal. Also, I want to make sure you understand, Mr. Murray, you're going to go into custody today. You'll be in our jail for just a couple of weeks, probably. I don't think there's a big waiting time to get to ISF. But while you're in our jail and while you're at ISF, it's part of your conditions of your probation now that you follow all of the rules and be courteous and treat everyone that is working there with respect. So don't go get in our jail and start getting involved with some of the people out there that are not doing that. If you get an incident report while you're in jail before you even go to ISF, it's a violation of your probation and you could never get out again without me revoking your probation. You understand? All right, you can go. Good morning, sir. Are you Jeremiah Douglas?
Yes.
And will your client waive the formal reading of the indictment in each case?
Yes, please, Your Honor. This robbery case highlights something viewers often misunderstand about probation. Many people hear the word probation and assume a defendant simply walks away without serious consequences. That's clearly not what's happening here. The judge is requiring completion of the ISF program, imposing strict supervision conditions, limiting contact with certain individuals, and making it clear that any violation could trigger a prison sentence ranging from 2 to 20 years. Notice how Judge Raquel repeatedly focuses on accountability and rehabilitation at the same time. She's essentially telling this young defendant, I'm giving you a chance, but I'm also giving you every tool you need to succeed. The court is balancing public safety with the possibility that a young offender can still turn his life around. It's a reminder that probation isn't freedom, it's an opportunity, and opportunities can disappear very quickly when court orders aren't followed.
Mr. Douglas, in cause number 25, DCCR 1115, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from July 27th of 2025. And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
That's fine.
And are you pleading guilty because you actually did what they charged you with? And then in cause number 25, DCCR 1222, you're charged with a second-degree felony offense of fraudulent use or possession of identifying information between 10 and 50 items, and that's from July 27th of 2025. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And because you actually did what they've charged you with? In both of those cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. West?
Yes.
Do you fully understand them? And do you understand, if I follow the agreements that you've reached with the district attorney, that you'll be waiving or giving up any right to appeal? And so it looks like the agreement in 1115 is for a 5-year deferred probation, a $500 fine, and any other conditions subject to the pre-sentence report. Is that correct?
Yeah.
That was primarily to entail a forfeiture in the UCW misdemeanor.
Okay. So as part of these plea agreements, that he's going to take care of the unlawful carrying a weapon and forfeit that. Is that correct? Is that your understanding as well? And then in cause number 1222, it's the same agreement, which is for a 5-year deferred probation, a $500 fine, and obviously the same conditions of probation, and also that you would take care of that unlawful carrying a weapon and forfeit that weapon. Is that your understanding? Do you also understand, sir, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Speak up, please.
Yes, ma'am.
State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Douglas is not competent?
No, not at all.
All right, sir, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of those pleas, find sufficient evidence in each case to find you guilty. However, I'm going to reset your cases for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your cases, and then we'll come back later for sentencing. You need to stop on your way out of the courtroom today to talk to probation, and she's sitting at that desk right there. All right, we'll see you back at sentencing. Yeah, I need,
I'll send it to you.
don't sign it. You have to sign his right now.
Yeah, I didn't think right now.
And I need it emailed. It has to be emailed today.
Yeah, I will. There you go.
Mr. Galmore, you've got Lance, Laura.
Morning, Judge.
Good morning. Good morning, sir. Are you Lance, Laura?
Yes, ma'am.
And this is 25 DCCR 1912. Mr. Laura is charged with failure to comply with sex offender registration requirements. Mr. Galmore, what is the announcement?
Judge, just asking for one last announcement day. I'm going to have him come in and look at some discovery with me, and we'll be ready to either announce trial or cruise off in case the next day.
Any issues?
No,
All
you're
right, this will be the last reset. It looks like you were hired in January, so that'll put us about 7 months out. You need to make sure, make an appointment, go visit with Mr. Galmore, so you guys are ready to make that announcement at the next board date.
Yes.
Okay, see you then.
Thank you.
Thank you. Good morning, sir. Are you Miguel Reyna?
Yes, ma'am.
This is 25 DCCR 1687. Mr. Reyna is charged with driving while intoxicated, third or more. And what is the announcement?
Your Honor, if we can get, we're still working through our contractor obligations. We're getting close to the finish of that. I don't believe this is super old. If we can get another new setting.
This will be the last reset. It looks like you were hired in January.
Yes.
So, Mr.
Yes.
Reyna, make sure you stay in touch with Mr. West because you guys need to visit before that court date. Take care of whatever you're supposed to because we have to get an announcement that next court
And
date.
he's been in good communication. That's not an issue.
All right, we'll see.
Make sure that it's still not driving.
Mr. Reyna, you're not driving, correct?
He is, but he has an interlock device. He had just recently paid for it. He sent me a copy of the receipt.
Okay.
It's updated.
Make sure you don't drive any vehicle that does not have that interlock device on
I'm very
it.
careful about it. He's always
Okay.
listening to me every month. He tells me.
All right, we'll see you about Smith sentencing.
Sorry.
It's John Jackson. All
Absolutely.
right, sir, are you John Jackson?
Yes, Your Honor.
This is 24 DCCR 1968. Mr. Jackson was previously in court, entered a plea of guilty to aggravated assault with a deadly weapon. I've received the pre-sentence report. Have you both had an opportunity to review the report?
Judge.
Yep, Judge, sorry, I have all the Christmas files organized. I can just grab it real quick because he had a couple things happen.
Okay,
We have one, I'll call it clerical correction, Judge.
I'll defer to Mr. Gertz first, Judge.
go ahead.
On page 3, under monthly expenses. When Mr. Jackson filled out the monthly expense amount, he inadvertently left off taxes that he has to pay. And so he would say his expenses are $983 for investments.
All right,
We have no other corrections, objections, or changes.
thank you.
And we're
Ms.
asking
Malvina.
to follow the agreement.
Thank you, Mr. Gertz.
Judge, I'm obviously aware of the case after review of the PSI and in discussion multiple times with Mr. Smith about it. And I believe the concern the state would have would be the comments made in the defendant's version. But we'll defer to the court with whatever you deem is appropriate for final resolution.
So it gave me some current concern also, Mr. Jackson, about the level of responsibility that you are taking about what happened that day. Obviously, you understand that what happened that day is not how you handle any type of situation like that. Do you understand? All right, sir. So what I'm going to do is find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, but I'm going to follow the agreement that you made with the district attorney, defer all proceedings, place you on probation for 10 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. One of those is that you are not allowed to possess a firearm at all. Do you understand? That's in your home. No one else can have one. No access to any firearms. You understand?
Yes, Your Honor.
Also, there's going to be a mental health evaluation just to see if there's any issues that need to be taken care of while you're on probation so that they can give you whatever help you need to be successful. If you do everything that you're supposed to while you're on this probation, it's a great opportunity because you don't have a felony conviction on your record. And if you successfully complete the probation, the case will be dismissed. You'll never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sent to prison for anywhere between 2 years and up to 20 years. Do you understand?
Yes, Your Honor.
I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. If you'll just have a seat here in the courtroom, probation's going to call you up when she's ready to go over your paperwork. All right. 8. You're charged with a third-degree felony offense of failure to comply with sex offender registration requirements from August 11th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And are you pleading guilty because you actually did what they've charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Gertz?
Yes, Your Honor.
Do you fully understand them?
Yes, sir.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, sir.
Is this a 3-year sentence over 5?
Yep.
3 over 5 years.
So it looks like the agreement that you've reached is for a 3-year term in prison, but that would be probated. You'd be on probation for 5 years, ordered to pay a $750 fine, and ordered to follow all of the rules and conditions of probation. Is that your understanding?
What a fascinating courtroom session. We saw defendants reject plea bargains, others accept responsibility through guilty pleas, and several people receive stern warnings about what could happen if they violate court orders in the future. One of the strongest themes throughout today's proceedings was personal responsibility. Whether discussing probation, plea negotiations, firearm restrictions, treatment programs, or future sentencing, Judge Raquel consistently emphasized that every defendant was being given a clear understanding of the stakes. Some were granted opportunities to avoid permanent felony convictions through deferred adjudication, while others were reminded that future violations could lead directly to prison time. The message from the bench was simple. Second chances exist, but they come with obligations and consequences. Courtrooms are often where critical life decisions are made, and today's hearing showed exactly how high those stakes can be. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Let us know, which case stood out to you the most, and would you have made the same decisions as these defendants?
Is that your understanding?
Yes, sir.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, sir.
State tenders number 1.
We have no objection, Judge.
It's admitted. Is there any evidence that Mr. Landry is not competent?
None at all, Judge.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll just give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there. All right, we'll see you back at sentencing.
Thank you.